हेलो बच्चा लोग, हेलो एवरीवन, वेरी गुड आफ्टरनून एंड वेलकम बैक टू योद्धा बैच. सो ऑल CSEET November 24 एस्पिरेंट्स, आर यू रेडी? सब लोगों ने अच्छे से रिवाइज कर लिया है? सब लोगों ने जो लेक्चर्स अटेंड किए, एवरीथिंग इज रेडी, राइट? एंड अगर आप सीरीज से बहुत ज़्यादा बेनिफिट होने वाला है. Yes, as you know, we have started Yodha series 2 days back and today we are going to continue with legal aptitude. Legal aptitude में हम लोग आज करने वाले हैं इंडियन कॉन्ट्रैक्ट एक्ट. Yes, सभी का फेवरेट इंडियन कॉन्ट्रैक्ट एक्ट 1872. एंड इसमें हम क्या करने वाले हैं फ्रेंड्स? इसमें वी आर गोइंग टू सॉल्व MCQs, राइट? ऑब्वियसली जो MCQs आपने क्लास में सॉल्व किए थे वो अलग थे, एंड दीज आर MCQs अदर देन दोज ऑब्वियसली. एंड MCQs सॉल्व करते करते वी आर ऑल्सो गोइंग टू रिवाइज, यस, टॉपिक वाइज. तो शुरू करते हैं विदाउट वेस्टिंग एनी टाइम, राइट? सो आर यू ऑल रेडी? शुरू करें? यस. सो लेट्स एड ऑन समथिंग टू योर November 24 examination. Yes, so Indian Contract Act 1872. The first question I want everyone कि आप लोग जब क्वेश्चन डिस्कस हो तो लाइव चैट में आंसर्स भी लिखें, राइट? एंड वी कैन हैव अ टू वे कम्युनिकेशन. Yes, so are you ready everyone? Let's go. So friends, yes, here we go. Indian Contract Act 1872. Here is the first question. What does it say? So friends, a contract is any dash between two or more parties which is enforceable by law. Very simple question. Yes or no? A contract is any dash between two or more parties which is enforceable by law. So now you can see that friends, this question is connecting directly with the definition of contract. Yes. Can you people tell me the definition of contract is given in which section number? Yes, obviously it is section number 2. As you know, all definitions are given in section number 2, right? To what? Definition of contract. Come on. Section 2, subsection H. Section 2, subsection H. Contract. Definition of contract. Yes? Okay. So friends, what is a contract? Contract is an agreement which is enforceable by law. Yes, you people have a very good energy. I can see so many answers on screen. Superb. Yes. So friends, answer is contract is any agreement which is enforceable by law. So this was the definition. Let's go further to the next one. Friends, next is what is meant by consensus ad idem. Yes, now consensus ad idem is a Latin maxim. Yes, which means what? Which means meeting of minds. Which means what friends? Meeting of minds. As you know friends, when we talk about essential elements for a valid contract, yes, again I am repeating, as you know we discuss about essential elements for a valid contract. Yes, there are so many essential elements, means the basic ingredients to make a contract valid. Now in that, consensus is also very important. Yes, that is meeting of minds. Consensus ad idem refers to what friends? Meeting of minds. So here you can see the answer is option C. Yes, agreement. That is agreement upon same thing in the same sense. So what do you think friends? Is it necessary for the parties? Is it necessary for the parties to come together? Yes. Is it necessary for the parties to come together means agree upon same thing? Yes. Only then there can be an agreement. Like for example, if I agree to sell my phone, you should agree to buy my phone. Only then there can be an agreement. Yes or no? So that is called as consensus ad idem, which is very much essential to make a contract valid. Right? Let's go further. Next is every promise and set of promises forming consideration for each other is dash. Come on, every promise and set of promises forming consideration for each other is dash. Come on, what is the answer, friends? What is this? Answer is, come on, anyone? Yeah, answer is agreement. You know, friends, see what is agreement? So in the basic sense, if we see, agreement refers to offer plus acceptance. Come on, everyone with me. Offer plus acceptance. Yes or no? So offer plus acceptance makes an agreement between parties. Correct? Now friends, in this case, you know the another word for agreement is what? Another word for agreement is promise. Yes. So friends, whenever we say an offer, whenever the offer is accepted, it becomes dash. I repeat, whenever the offer is accepted, it becomes dash. So answer is yes, it becomes a promise. Right? Yeah, generally students say that it becomes an agreement, but another word for agreement is promise. So what are the answer? Yes, answer is agreement. So basically in screen you can see, this is on screen, you can see this is the definition of agreement, nothing else. Right? I hope this is clear to everybody. Yeah, and let's go to the next one. I hope this type of revision helps you. I hope you all are ready for the main day challenge. Few days left for your exam, and K SHAH classes is coming up on time. Revision for all across India CSEET students. Yes, after this, after achieving this goal, you know we have a very big challenge coming up, that is a CS executive. Right? We are going to break that challenge. We are going to achieve that very easily in a planned manner. I hope you all are ready for that also. Yeah, so let's go to the next one. So next is, as per Indian Contract Act 1872, what is an agreement which is not enforceable by law? What is an agreement which is not enforceable by law? So see friends, whenever we discuss this, whenever we say valid contract, it means what? It is an agreement which is enforceable by law, right? And whenever we see void contract, it means what? Void contract means agreement which is not enforceable by law. However, there can also be contracts which are not enforceable by law. Yes, void agreement, void contract. So basically void means what? It means not enforceable by law. So answer is option C, because here they are asking about not enforceable by law. So not enforceable by law refers to void, right? Yes, very nice energy. Everyone here live, everyone is getting so many good answers, perfect answers. Superb, superb, very nice. So let's go to the next one. Domestic arrangements between husband and wife is not a contract under Indian Contract Act 1872 because dash. Because dash. Now see friends, whenever we discuss about this, again we have to go to the essential elements for a valid contract. You know friends, when we talk about essential elements for a valid contract, there are so many things, right? Like there are around 10 points, 10 things. You know, because whenever a student studies Indian Contract Act, there is one confusion. What is that confusion? Whenever I say contract is an agreement which is enforceable by law. So student is asking always one thing, sir, which agreements are enforceable by law? Which agreements are not enforceable by law? This is the problem. Student cannot determine that. So answer to this confusion is, friends, if all essential elements for a valid contract, all essential elements for a valid contract is present, yes, in your agreement, then your agreement is enforceable by law. And one of the essential element is legal obligation. Yes, what it is? Legal obligation, that is legal relationship. You know friends, see, agreement means what? Offer plus acceptance. There can be so many offer and acceptance. Like for example, if you enter into an agreement with your friends, if you give an offer to your friend, that is, will you buy my phone? Will you come for a movie? Offer. Now what if your friend accepts the offer? If your friend is accepting the offer, so it is offer plus acceptance agreement, right? Now you know, once the agreement is formed, now both the parties have to perform their respective obligations. Yes or no? But friends, what if the friend agreed to come for a movie and now he refuses to come? Now he breaches your agreement. Come on, tell me, can you sue your friend? Can you file a suit against your friend for not coming for a movie? The answer is no. Why? Because there is no legal relationship between these two parties in this agreement. Tell me, is your friend under a legal obligation? Is your friend under the legal duty to come for a movie? No. Therefore, legal obligation is missing. Therefore, such agreements are called as domestic agreements. These agreements are called as what, friends? Domestic agreements. And domestic nature agreements are never ever enforceable by law. These are never ever enforceable by law. I hope this is clear. So friends, here you can see the option is very clear. Anyone would like to answer this? Come on, agreement between husband and wife. I can take one more example for this. You know, today what happened? My wife called me. She called me and she's asking me, should I make masala dosa for you? She's giving me an offer. Right? Should I make dosa for you? Offer. So I told yes, why not? So I accepted the offer. So offer plus acceptance. There is an agreement. Correct? Now there is formation of agreement. In this case, now what is duty of wife? Duty of wife is to make dosa as per the agreement. What is my duty? To eat dosa. Now as per the agreement, she has prepared the dosa. I went home and now I refuse to eat dosa. Come on, tell me. Wife has performed her obligation? Yes. Have I performed my obligation? No. Can wife sue me for not performing the agreement? For breaking the promise? Can wife sue me? Answer is no. Why? Because it was not my legal obligation to eat dosa. Obviously not. Yes or no? So friends, here as the legal obligation was missing, this is not enforceable by law. Right? So again, I would like to highlight that creation of legal relationship is important to make a contract valid. So answer is option D. There is no intention to create a legal relationship. Is this clear to everybody? Yes. Let's go further to the next question. So friends, next is, yes, next question. Next question in your Yodha series, Indian Contract Act with K SHAH Classes, Professor Meet Sachdev. Your next question is, are you all ready to answer? Yes. So next question says that if a new contract is substituted, if a new contract is substituted in place of existing contract, it is called as dash. Come on, a new contract is formed substituting the existing contract. It is called as dash. What do you think? What it is? So friends, let me tell you, answer is novation. Yes. What is novation? Friends, novation means substitution of contract. What it is? Substitution of contract. Shall I explain you? You can see option A is alteration. Alteration means what? Changes. Change in a contract. Okay. Option B, you can see rescission. Rescission means cancellation of contract. That is to resign, to cancel. Option C, novation, means substitution of contract. Means whenever we enter into a new contract, replacing, substituting the old one, it is called novation. Yes. So friends, tell me one thing. I'll take one example for this. Please concentrate everybody, okay? See, suppose A and B. There was some transaction between these two parties. So, there was some contract between these two parties, okay? Now, in this contract, A was liable to pay 10,000 rupees to B. A was liable to pay 10,000 rupees to B. That is a part of obligation which A has to perform in the contract, okay? And there was another transaction between C and A. There was another different transaction between C and A, okay? Now, under this contract between C and A, you know, C was liable to pay how much? 10,000 rupees to A. See the coincidence, right? C is liable to pay how much? 10,000 rupees to A. Okay everyone, concentrate please. So C is liable to pay 10,000 rupees to A under a contract, and under a different contract A is liable to pay B 10,000 rupees. Okay, so this was the case. Now what A told? A told Mr. C that, see Mr. C, you will give me 10,000, then I will give 10,000 to Mr. B. Why don't you directly make payment to B? Are you getting it? Why don't you make a direct promise to B? Are you okay with it? Mr. C told, okay, no problem. Mr. B, are you okay with it? Mr. B is also okay with it. So what Mr. C did? Mr. C made a new promise. Yes, Mr. C made a new promise. Promise means agreement, right? So there was a new contract between C and B. Yes, new contract, that is to pay 10,000 rupees to Mr. B. Okay. Now friends, you can see a new contract was made. Okay. Now tell me one thing. If Mr. C makes this payment, what if Mr. C perform this obligation? Then can I say, then C is not required to perform this promise? Yes or no? Then if C don't pay money to A, then it is absolutely fine. Yes or no? Then this will be the contract which is not required to be performed. Which one? This one. And also, now even A is not required to pay money to B, because B has already received the money. Yes or no? So friends, can I say, if the new contract is performed, these two contracts are not required to be performed now. Now these two contracts are not required to be performed. So friends, have you understood this? The new contract was made substituting those two contracts. I repeat, new contract was made substituting those two contracts. This is called as what? This is called as novation. Substitution of contract. Substitute. Yes, to substitute. Okay, so that's what the question was about. If a new contract is substituted in place of the existing one, it is called as novation, substitution. And remember one more line about novation. This type of situation, novation can be done, substitution can be done only with the consent of all the parties. Yes, you saw Mr. C entered into a new contract with Mr. B, right? So this can be done, this is possible only with the consent of all the parties. That is, you need to take the consent of Mr. A, B and C, all the three parties. Then it is allowed. So I hope this example was useful and everybody has understood what novation means. So novation is nothing but simply it means substitution, and I have also explained to you the meaning of alteration, cessation, right? Yes, waiver is like give up, to let go the contract, not to take action and all. So let's go to the next one. I hope this is clear. So next question, yes. Which of the following is not an essential element for a valid contract? Which of the following is not an essential element? So friends, when we talk about essential elements, what all things are essential to make a contract valid? So yes, if we can just revise that also, what all things are essential? Come on friends, tell me. See, all the options are given here. Firstly, you tell me, is offer and acceptance the basic requirement to make a contract valid? Yes, offer plus acceptance. Then after offer plus acceptance, next one is legal obligation. Legal obligation is required. Then we need mutual consent of parties, that is consensus ad idem, meeting of minds, right? Then you have parties must be competent to contract. Everyone cannot enter into a contract. There are few parties who are not allowed, like minor and all, right? Then next one is, after capacity of parties, you need lawful consideration, right? Then you need consideration, something in return. Then agreement, the object of agreement must be lawful. Then there must be free consent of parties. Then agreement must not be declared as void. Meaning of agreement must be certain, and performance of agreement must not be impossible. Performance must not be impossible. So this 10 points, you have to remember this 10 points. If this 10 points are getting satisfied, then your agreement is a contract. Then your agreement is enforceable by law. Right? I hope this is clear to everybody. So let's check it out. Which of the following is not an essential element? Come on, tell me. Is offer an essential element? Yes. Second one, legality of object. Yes. What do you think? The object must be legal? Yes. Lawful consideration? Yes, consideration is the basic requirement, because no consideration, no contract. If there is no consideration, there is no contract. Next, impossibility of performance. What do you think? Performance must be impossible. No. Performance must not be impossible. Right? So obviously, which of the following is not an essential element? So when we say not, so obviously A, B and C, these are essential element. So answer will be D, impossibility of performance. Yes, I would like to appreciate once again all the students who are, yes, answering so actively in the chat box, and yes, all the answers are correct. That is very nice and superb. So let's continue the next one. So friends, next is question number 8 is cash withdrawn by a consumer of a bank from an automatic teller machine is an example of dash. Yes, a person is withdrawing cash from ATM. This is example of dash. What is the answer? So friends, very simple. Answer is C. Is this a void contract? No. Void means it is not enforceable by law. Then is it express contract, use of words, oral return? No. Is this a bilateral contract? No. This is a agreement. This is a contract which is formed by the conduct of party. That is by the act of party. So friends, answer is tacit contract. You know tacit contract, you studied the tacit contract in types of contract. Yes, it is a formation of agreement by the conduct of party. So answer is tacit. Yes. We go to the next one. Dash is a contract in which only one party has to perform his part of promises. You can see this is a bit surprising for all of you, right? So this is a contract in which only one party have to perform. What do you think, friends? Only one party have to perform. Sir, but we have studied that in a contract both parties have to perform. True, both parties have to perform. But this one is a contract in which only one party have to perform. Sir, are there any such type of contracts? Yes. See, firstly, a contract where both parties have to perform is called as bilateral contract, right? Then contract in which only one party have to perform is called as unilateral contract, correct? So here you can see they are asking a contract in which only one party have to perform. That means it is a unilateral contract. Yes. Sir, are there any examples for this? Yes. Friends, you all have studied consideration. You all have studied a topic, no consideration, no contract. Right everyone? Yes. So in this topic, no consideration, no contract, there are exceptions also. So when you study the exceptions of no consideration, no contract, you will see in that case, parties, only one party have to perform. Other party don't have to perform. Yes, all the exceptions of no consideration, no contract, yes, that is unilateral contract. All such contracts are unilateral contracts. Like for example, you know there is one point, out of natural love and affection. Yes, out of natural love and affection. Now friends, in that case, suppose there is a husband and wife. Husband promised to pay wife monthly expenses because they both got separated. They got separated, there was no divorce, okay? So husband promised to pay monthly expenses, let's say 50,000 to wife. So he made a promise, means there is an agreement between these two parties. Now tell me, in this agreement, what is consideration for husband? Nothing. Husband is not getting anything in return. What is consideration for wife? Wife is getting money. Are you getting my point? So you can see there is one party who is getting consideration, another party who is not getting consideration, right? So husband has made a promise to pay monthly expenses. Now if husband don't pay, can wife sue? Can wife sue? So generally students will say, no sir, wife cannot sue because no consideration, no contract, right? But in this, wife can sue if the 4 conditions are getting satisfied. Yes, I am talking about exceptions. So if there are 4 conditions which are getting satisfied, like if that agreement was in writing, if that agreement was signed by the party, if the promise was made, agreement was made out of natural love and affection, right? Yes, and that agreement was registered. So if the 4 conditions, I repeat, agreement is in writing, signed by the parties, there was love and affection, and agreement was registered. If these 4 conditions are getting satisfied, then even if there is no consideration, it is a valid contract. I repeat, even if there is no consideration, it is a valid contract. So now tell me, it is a valid contract, right? So in this valid contract, what is the obligation of husband? To pay the money. What is the obligation of wife? Nothing. Wife don't have to do anything in that. So you saw in this contract only one party was performing. So therefore this is a contract in which only one party have to perform. That is called as unilateral contract. It is a unilateral contract. I hope this is clear to everybody. Easy? Yeah, let's go. Next. Next is dash is a contract where parties to contract have yet to perform their promises. Come on. Dash is a contract where parties still have to perform. Now friends, this type of contract here we can, easily we can come to a conclusion. You can see the options: executed contract, right? Then it is executory contract, void contract, variable. So what is the answer? Parties still have to perform. So answer is very simple, option C. That is executory contract. What are executory contracts? It is a contract in which parties still have to perform. Parties still have to perform. Yes. So see, if there is a contract in which both the parties have already performed their obligations, such contract will be called as executed contract. I repeat, such contracts will be called as executed contracts. Okay. And when we talk about executory, means a contract where parties still have to perform. They will be performing the obligation, right? I hope you have understood this. So friends, we are done with the first 10 MCQs. Yes, I hope this is helpful. Yes or no friends? Can you write in the chat box please? Are you all learning something? Are you all revising? Is Yodha series useful? Are you going to attend all the lectures of Yodha series, everyone? Yes, 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 yes. So, let's continue. Friends, 11th question. Yes, so 11th question you can see, that is, yes, 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 full of energy. Yes, thank you, thank you, thank you. Chalo. So, next one is Mahavir Tour Operators operates a super AC buses from Jaipur to New Delhi. Okay, Jaipur to New Delhi. They operate AC buses from Jaipur to New Delhi. The bus is standing at the bus stand in Jaipur, waiting for the passengers traveling to New Delhi and is ready for departure. There is and dash for passengers to board the bus. Come on. Yes, I have already received so many answers in the chat box. Superb energy, everyone. So answer is obviously implied offer. You know friends, there are types of offer, right? So what is implied offer? So basically there are the 2 types. One is express offer and another is implied offer. Come on, come on. Express offer and implied offer. What is express offer? Express offer means use of words. Use of words, that is by oral or written. So whenever you make an offer orally or in writing, such an offer is called as express offer. Okay. Now, if you make an offer not in an express form, that is no oral, not even in writing, it is just by the act or conduct of parties. That is, see, there was just an act done by a party. The act is done, an offer is done. Yes, example is this. Friends, if a bus is coming and bus takes a halt at the bus stop. What is this? Come on, if bus comes and bus takes a halt at the bus stop, this is nothing but an offer. The bus service provider is giving an offer to the passengers waiting at the bus stop. Yes. Tell me this bus people, the bus service provider is going to, give you any shout like anyone is coming to New Delhi, no, nothing. The bus is just standing at the bus stop. The bus standing at the bus stop is nothing but the act done by the bus service provider. So this act done is nothing but an implied offer to the passengers waiting at the bus stop. Come on, I want to extend this. You tell me one thing. Is it necessary to accept this offer? Obviously no, it is not necessary to accept the offer. But if you wish to accept this type of offer, how can you accept it? Come on, what you need to do if you want to accept such type of offer? Can I say once you board the bus, it is an acceptance. So that boarding the bus is acceptance, yes or no? Okay, tell me one thing, the boarding the bus is what type of acceptance? Is it express or implied? It is express or implied? It is implied acceptance. It is implied acceptance. This is implied offer, this is implied acceptance. So here we have formed what? Implied agreement. Yes or no? And yes, this agreement is enforceable by law, therefore this is a contract. This is an implied contract. Because once you board the bus, I am repeating again, it is not compulsory to board the bus. It is not compulsory to accept the type of offer. But if you board the bus, it becomes an acceptance. So if there is an acceptance, if there is offer plus acceptance, there is an agreement. Yes, there is an agreement. So now once there is formation of agreement between parties, both the parties have to perform their respective obligations. What is our duty? Our duty is to pay the fare. What is the duty of bus service provider? Bus service provider's duty is to drop you at your destination, that is to provide you service. What if bus service provider drops you at your destination and you don't buy the ticket, you don't pay the fare? Yes, in that case, can the ticket checker fine you? Yes, he can fine you. If you don't pay the fine, can he take you to court? Yes. Will law punish you? Yes. So if law punishes you, why law is punishing you? Because you have not performed your obligation, which was part of the agreement. So the agreement, the offer plus acceptance, this agreement is not enforceable by law or enforceable by law. What do you think? Generally students think that, sir, traveling in a bus is not a contract. It is not enforceable by law, but this is enforceable by law. Because it is your duty to pay the fare, it is the duty of bus service provider to take you at your destination. If any of the parties does the breach, the other party have a right to sue. Yes or no? So it is, yes, law is going to punish you because you have not performed your obligation. Therefore, it is a valid contract. Okay, we come back to the topic now. So our question was about the implied offer, but we were just discussing about the entire situation. Fine. Let's go further. Next one is, dash is only a circulation of an offer. Okay. It is an attempt to induce offers and it precedes a definite offer. Come on, what is this? It is only a circulation of offer. Okay. It is an attempt to induce offers and precedes a definite offer. What is this? So friends, basically here we can clearly see we are not talking about offer, because we are talking about an act which induces offers. It clearly says that it precedes a definite offer. So what is the answer? Answer is very simple. Answer is invitation to offer. What is invitation to offer? All advertisements, any act due to which person makes an offer, it is called as invitation to offer. Right? All advertisements are called as invitation to offer. Yes, and obviously first step is invitation to offer, which leads to offer and then acceptance. Then it is agreement is formed. If that agreement is enforceable, then it is called as a contract. Come on, next. Now next question. A offers B to supply books at 100 rupees each, but B accepts the same with a condition of 10% discount. This is a case of dash. Now see friends, in this question, again we are going to the types of offer concept. So a person is making an offer. right? Will you buy the book at 100 rupees each? So what was the reply? The opposite party agrees to buy the books, but at 10% discount. So the opposite party agrees to accept the offer. Opposite party agrees to accept the offer with a condition. With a condition. What was the condition? 10% discount. So tell me, can I say when I made an offer, when A made offer to B, the B's reply was a conditional acceptance. B's reply was conditional acceptance. Do you agree, friends? Yes, it was a conditional acceptance. So now you tell me, is a conditional acceptance a valid acceptance? So answer is no. As per the features of acceptance, it says that acceptance must be, yes, correct, absolute and unconditional. Acceptance must be unconditional. Your reply should be yes, means yes, unconditionally yes. But here B says that yes, I will buy the book, but at 10% discount. So the conditional acceptance means what? So friends, obviously here you can see option A is the right answer, that is counter offer. Because when an offer was made by A, what B did? B accepted his offer? No. B rejected his offer? No. What B did? B ignored his offer and B made a fresh offer. B told, yes, I will buy it, but will you offer me 10% discount? So he is offering something new thing, right? He's making a new offer. He's making a fresh offer of 10% discount. So this reply, that will you give me at 10% discount, this reply is acceptance? No. This reply is not an acceptance. Friends, this reply is a counter offer. Because when you ignore the original offer and you make a fresh offer, it is called as counter offer. Basically, it means bargaining. Yes? So answer is counter offer. Because now, in order to form an agreement, can I say now A will have to first reply whether he agrees with the discount offer, whether he agrees with the 10% discount. Are you getting my point? So the reply of B was not an acceptance. So answer is A, counter offer. Okay, let's go. So what's next? When the goods are displayed in a show window bearing price tags, it indicates dash. Come on, here in this question we are talking about display of goods. Yes, we are talking about what? Display of goods with price tag. So friends, in a shop, if the goods are displayed with price tag, obviously goods are displayed there, it was done by the seller, obviously, right? So when the seller displays the goods, yes, in that window with a price tag, will this be considered as an offer? Is this an offer? What do you think? Display of goods with price tag is an offer. So answer is no. Display of goods with price tag, whenever you see any type of stickers, hoarding, sale, 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 50% off, all these stickers, when you see hoardings, you see all these are not an offer. It is invitation to offer. The seller is trying to invite people, please come and make an offer. By display, what is he doing? He is inviting people, please come and make an offer. So what do? We see those hoardings and we enter the shop. And then we make an offer. We tell him that, will you sell me this article? So whenever you are telling this, will you sell me this? Will you sell me that? This is an offer. So what was the first step? Display of goods. So that display of goods is nothing but invitation to offer. Because that was inviting public to come and make an offer. Right? So yes, display of goods with price tag indicates an invitation to offer. Okay, next one is offer made without any spoken words or return is dash. Come on, can you answer this? Offer made without any words spoken or written. So I already explained you this part in the previous questions, that is express offer and implied offer. So whenever we talk about express offer, yes, what it is? Use of words, oral or written. And whenever the offer is made by the conduct of party, act of party, means no use of words, no express, it is called as implied offer. So yes, option C is the right answer. Yes, I hope everyone is clear. Let's go further. Dash means exchange of identical offers in ignorance. Come on. Dash means exchange of identical offers. What is identical offers? Identical offers means, you know, same offers. Like for example, A wrote a letter to B making an offer. Okay. The offer given by A was, A told, will you buy my bike? Will you buy my bike? So offer. This is one offer. But friends, at the same time, what B did? Same time, B also unknowingly wrote a letter to A. Unknowingly. Yes. What B told? B told Mr. A, will you sell me your bike? Will you sell me your bike? Come on. Now see here, you can see there are two offers. Yes, there are two offers which are crossing each other. Tell me one thing, both the offers are talking about bikes. So are these two different bikes or the same bike? Both are talking about same bike. That bike belongs to Mr. A. So A told, will you buy my bike? B told, will you sell me your bike? So these two offers are made at the same time for the same thing. Therefore we say that these offers are identical offers, right? So friends, these offers are called as what? These offers are called as cross offers. Yes, these offers are called as cross offers. So answer is cross offer. I hope this is clear. Yeah, let's go further then. Next, an offer may be revoked by the offerer at any time before dash. Come on friends, here the concept is talking about the revocation of offer. Friends, once we make an offer, once you make an offer, can you revoke your offer? Can you take back your offer? What do you think? Can you take back your offer? Come on, I have already made an offer. Can I take back my offer now? Can I revoke my offer? Is revocation of offer valid? So friends, what is the answer? Answer is yes, you can revoke your offer, but offer can be revoked only before acceptance. Only before acceptance. Why? Because once the offer is accepted, it becomes an agreement. Yes or no? It becomes an agreement. It becomes an agreement, means it becomes a obligation, right? So yes, then agreement cannot be revoked. So yes, offer can be revoked, but only before acceptance. So answer A is the right answer. I hope everyone is clear. Yes, let's go further then. Next question. Yes, what it is. So next question says that Clark owned a dog named Cookie. Okay. One day during an usual walk, the dog ran away and Clark could not trace it. Clark offered a reward to anyone who finds the dog and returns the dog, right, will get the reward money. The fetch found the dog and returned it to Mr. Clark before being aware of the offer was made by the clerk. Few days after the incident, Fetch out a suit against Clark claiming the reward money, but Clark refused to pay. Which of the following options would be correct outcome of this case? So you saw here Mr. Clark lost his dog. He lost his dog and then he made an offer. Yes, that is to anyone who finds the dog will be getting a reward. Okay. So now what happened? Fetch found the dog. So you can see the offer which was made by Mr. Clark, that whoever finds the dog will be getting a reward. Correct? So tell me friends, what type of offer is this? Anyone who finds the dog will be getting a reward. Can you tell me the type of offer? Which type of offer is this? Obviously this is a general offer. This is a general offer, right? So friends, who can accept this offer? Answer is anybody who is aware about the offer can accept the offer. Very important. Anybody who is aware about the offer can accept the offer. Correct? So what happened now, friends? The fetch found the dog. That means fetch has done the activity of acceptance. So offer and acceptance. But fetch found the dog, returned it to clerk before being aware about the offer made by clerk. Yes, means he was not aware about the offer. Are you getting my point? Yes, means at the time of acceptance, at the time when he found the dog, he was not aware about the offer. So friends, if he was not aware about the offer, so what was the act he did for, like what was that acceptance act he did for? So basically there was no acceptance because he was not aware about the offer only, right? So friends, the rule says that offer can be accepted by a person who is aware about the offer. I repeat, offer can be accepted by a person who is aware about the offer. Tell me, was this Mr. Fetch aware about the offer? No, he was not aware. So can he accept the offer? No. So he found the dog, he returned it. After a few days he came and is demanding the reward price, and now Mr. Clark refused. So tell me, in this case what will happen? Can Fetch sue Clark? Will Mr. Fetch succeed? So answer is no, he will not succeed. Why? Because he was not aware about the offer. Offer must be communicated, friends. Yes, offer must be communicated. Yes, well said. A student has given the statement, yes, in the chat box. This situation, yes, directly gets connected with the case law Lalman Shukla versus Gauridat. Superb. Very nice. So now we go to the options. I am very confident that students can answer without referring to the options also. Students understood the situation without looking at the options also. Am I correct? Everyone? Super. Yes. So let's see the options now, because we need to take one answer. So yes, the fetch will not be entitled to reward as this was illegal contract. So no, that is not the answer. Fetch will be entitled to reward. No, he will not be entitled, right? Then fetch will be entitled. No, he will not be entitled. And the last one is fetch will not be entitled to reward because acceptance of an offer in ignorance of an offer is no acceptance. Superb. So option D is the right answer. That is, he was not entitled for the reward because acceptance of offer, accepting an offer in ignorance of offer is no acceptance. So the conclusion is, who can accept the offer? The offer can be accepted by a person who is aware about the offer. Okay, done. Let's go to the next one. Yes, next question is, a contract can be performed by dash. Who all can perform the contract? So friends, once the contract is entered, next step is performance basically. Performance means what? You need to perform any dance? No. Once the contract is entered, next step is performance, means both the parties have to perform their respective obligations. Means whatever obligations, whatever promises they have made, they need to fulfill that. Correct? So who all can perform the contract? So let's see. First option, promisor himself. What do you think? Can promisor himself can perform? Yes. When will promisor himself have to perform? Whenever in a contract personal skill and talent is required for performance. In that case, promisor himself will have to perform. Okay. Next, agent of promisor. Can agent of promisor perform? Agent means a person who is acting on behalf of another. So can agent perform? Yes. When? So answer is whenever the personal skill and talent is not required for performance, agent can also perform. Okay. Next, legal representative of promisor. Can legal representative of promisor can perform? So again answer is yes. That is in case of death of party or insanity of party. Right? Like after formation of contract, if any of the party dies or if any of the party suffers insanity, so his legal representative will have to perform the obligation. So answer is yes, either of these three. So any of them can perform, depends on the situation. So contract can be performed by any of them. Next question. In a contract not specifying the time for performance, the promisor can perform the contract dash. Come on. See, a contract was made, a promise was made, but there was time which was not specified in the contract. Time was not specified, time of performance was not specified in the contract. So friends, if the time was not specified, in that case your performance must be when? After 1 year, after 10 days, after 15 days. Time is not specified, right? So friends, if the time is not specified, in such case performance must be within reasonable time. Performance must be within reasonable time. I hope this is clear to everyone. Okay, yes, so within reasonable time is the answer. Okay, what is reasonable time, friends? What is reasonable time? Anyone? Reasonable time means how much time? So answer is reasonable time is not defined in law. Reasonable time is not defined in law. Reasonable time is not the matter of law, it is the matter of fact. It differs from case to case. Reasonable time is not the matter of law, reasonable time is the matter of fact. It differs from case to case. Like what is the situation, depending on that you see the reasonable time. Yes, so I hope this is clear. Yeah, so answer is reasonable time. So in order to convert a proposal, proposal means offer, into a promise, promise means agreement, the acceptance must be dash. Come on, what do you think? In order to convert an offer into an agreement, that is offer plus acceptance, in such case acceptance must be dash. So this question is directly connecting with the features of acceptance. What is a valid acceptance? So friends, answer is what? Acceptance must be conditional, unconditional, uncertain, none of the above. So answer is obviously acceptance must be unconditional. Why unconditional? Because conditional acceptance is a counteroffer. Conditional acceptance is a counteroffer, right? I hope this is clear to everyone. Easy? Yes. Let's go further. Which of the following is unlawful object, unlawful consideration? Which of the following is unlawful object, unlawful consideration? Come on. First, forbidden by law, okay, immoral, fraudulent, all of the above. What is the answer? See friends, when you talk about unlawful object, unlawful consideration, so remember one thing, if you do anything which is forbidden by law, means prohibited by law. So obviously if you do something which is prohibited by law, it is unlawful. It is unlawful object, unlawful consideration, right? If you do anything which is defeating the provision of law, defeating the provision of law means something which is against the law, unlawful object, unlawful consideration. If you do anything, if there is a consideration which is causing injury to a person, I repeat, if there is a consideration which is causing injury to a person or loss of property, unlawful, right? Next one, if you do something which is immoral, fraudulent and opposed to public policy, all these things are what? Unlawful object, unlawful consideration. So if you see fraudulent, yes, fraudulent, immoral, yes, forbidden by law, yes. So answer is all of the above. Answer is all of the above. Okay, so next one. Under Indian Contract Act 1872, which one of the following is not essential element for a valid contract? Yes, which of the following is not an essential element? So friends, if you see the previous questions, we have done revision of essential elements for a valid contract, right? So friends, when you see essential elements for a valid contract, there are 10 points I told you, right? So in that you can see, come on, tell me, is legal relationship an essential element? Yes. Consideration is an essential element? Yes. The agreement's meaning must be certain? Yes. Free consent is essential element? Yes. All the four are essential element, but they have asked you which is not an essential element, right? So friends, if you see all the four are essential, But as per the rules, we have done in the features of consideration, we have done that consideration need not to be adequate. Yes, like for example, if you enter into a contract, you are getting a certain value in return, but that amount what you are getting is not sufficient. Will that make a valid contract? Will that make a valid consideration? So answer is yes. Because consideration need not be adequate. Consideration need not be adequate. Even if the consideration is not sufficient, it is okay. Yes, all the students of K SHAH classes, you all know, we took example of Dishu in class. Yes, so that was the case. You know, everyone, all other students, I'll tell you one story what happened. You know Dishu? Yes, my property worth rupees 5,000 crores with so many cars, swimming pool and everything. I transferred it to Dishu for just rupees 5 lakhs. We entered into a contract. I transferred it to Dishu just for rupees 5 lakhs. Value of the property was 5,000 crores. So tell me, by doing that contract, what is consideration for me? I got only 5 lakh rupees. Instead of 5,000 crores, I got just 5 lakh rupees. So will that be considered as a valid consideration? So answer is yes. Because consideration need not be adequate. I hope this is clear. Yes. So obviously consideration is an essential element, but here it says that adequacy of consideration. So here they are asking which is not an essential element. So answer is B. Okay, because they are talking about adequacy, that is, it should be sufficient, but actually it should not be sufficient. It is not required to be adequate. Okay, even if it is not sufficient, it is valid. So I hope this is clear. We move to the next one, that is the exceptions to the rule, a stranger to contract cannot sue are dash. Firstly, whenever we see this topic, stranger to contract cannot sue, yes, we are connecting this directly with a topic, that is doctrine of privity. You know what is doctrine of privity? The doctrine refers to, you know, principles, rules, theories of privity. So doctrine of privity means what? Doctrine of privity means, you know, only the two parties who enter into a contract can sue each other if there is any problem in the contract. If there is any problem in the contract, the two parties can sue each other. But can stranger to contract sue? Can third party sue? So answer is no. As per doctrine of privity, only contracting parties can sue each other, stranger to contract cannot sue. Okay, but there are few exceptions. There are few exceptions to this point. Exceptions means what? There are few situations where party can sue. And if we see the exceptions here, first is beneficiary in case of trust. Is this an exception? Yes. You know friends, if there is a contract between two parties, let's say there are two parties, okay. Now in this contract, the two parties, these two are contracting parties, they can sue each other if there is any problem. But the outsider, the third party, can sue if that third party is a beneficiary. Remember this, right? So there were different situations, like a beneficiary in case of trust. Yes, this was an exception. Written family settlement. Yes, this was also an exception. Assignment of contract. This was also an exception. Are you getting my point? So question was, exceptions to the rule, stranger to contract cannot sue a dash. Come on, which are the exceptions? So answer is all of the above are exceptions. Right? Yes. Let's go further. Next one. Agreement of which consideration is inadequate is dash. Come on, we have revised this few minutes ago. Agreement in which the consideration is inadequate. Consideration is not sufficient. Is that okay? If consideration is not sufficient, is that okay? What do you think? So friends, answer is it is absolutely fine. Just now I gave you example of that issue. Right? So agreement in which consideration is not sufficient, not adequate, obviously it is absolutely valid. It is not void. It is valid. Are you getting the point? Done. Next Next. So friends, we have finished 25 questions. In today's Yodha series lecture, Legal Aptitude Indian Contract Act, we have done with 25 questions. Yes, so I hope if you think that these types of lectures, sessions are helpful. You know, at CSET level, we conduct Yodha series for every batch, CSET batches. And for CS Executive, we conduct a very big revision series which covers not only questions but it covers complete revision, and that is very well known among students community, and that is called as Sanjeevani revision. Yes, at executive level you are going to do what? Sanjeevani revision after your batch is over. At CSET level it is going to be Yodha series. Yes, so we keep on doing such type of, it takes lots of efforts for all the teachers who do very hard work for the students, but I just want one thing from you. If you think such lectures are useful, just you can write a comment after the lecture is over. You can just hit a like button. Yeah, we are not YouTubers, but we are doing something for students. Thank you. Let us continue. Next, an agreement without consideration. Come on. Agreement without consideration is void except in case of compensation for dash. Come on. See, again we go to the topic, that is no consideration, no contract. You know, consideration is essential element for a valid contract. Consideration is an essential element for a valid contract. Yes or no, friends? Yes. So no consideration, no contract. If there is no consideration, there is no contract, right? But there are few exceptions. Exceptions means you will see in the few situations there is no consideration, but still it is a valid contract. I took one example today in this class, that is out of natural love and affection. Out of natural love and affection. Yes. So friends, similarly there are more exceptions. The second exception is, if you know, promise to pay compensation for past voluntary service. Promise to pay compensation for past voluntary service. This is also one of the exceptions, right? So here they are saying that an agreement without consideration is void except in case of compensation for dash. So what is the answer? So answer is in case of past voluntary service. That is option A is the answer. Okay. So see, like if suppose if I do something voluntarily for you, voluntarily means I'm not going to get anything in return if I do something voluntarily. Okay, and then let's say for example you have lost your mobile phone, and if I pick it up and if I return it to you, obviously I did this without any expectation of any reward or anything. Correct? So I have given what? I have given voluntary service. So that's it. I was okay. I don't want anything in return. But now if you promise to pay me that I will pay you reward money of X amount, so now will you have to pay? Is this a promise to pay compensation for the past services which I gave you? Yeah, because I have already given you the services. I have already returned you the mobile phone. Yes or no? So yes, in such case, if I have given any past voluntary service and if you make a promise, nobody told you to make such promise, right? But now if you make a promise, you will have to fulfill it, provided that promise is in writing. So this promise becomes a valid contract. So that is called as promise to pay compensation for past voluntary service. So option A is the answer. They have given other options also to confuse you, but it is very simple. Option A is the answer. Next one, in a contract, consideration under the provision of Indian Contract Act 1872 dash. In a contract, consideration under the provision dash. So what do you think? Consideration must move from promisee or any other person. It must move only from the promisee. It must move from the legal heir of promisor. It must move only from the legal heir of promisee. What do you think? What is the answer? So friends, again it is talking about consideration. We need to go to the features, and the feature of consideration was consideration may move. See, consideration is an essential element, right, for a valid contract. It is an essential element. So both the parties should get consideration, right? Suppose if we enter into an agreement with someone, okay, we promise to give something, and yes, this question is connecting to that case law. Very nice. That case law is what? Chinnaya versus Ramaya. Yes, which says that in an agreement, if you don't get consideration from this party, that is promising. The agreement you have entered, and if you don't get consideration from this party, that is fine. But you are getting consideration from another person. So, as consideration is not missing, it may come from promisee or any other person. Promisee or any other person. If you are not getting anything from here, but you are getting something from another person to perform the same promise, it is a valid contract. It is a valid contract, right? So I hope this is clear to everybody. So what is the answer? Answer is obviously option A, that is consideration must move from promisee or any other person. Yes, consideration must be there. That's it. It may come from promisee, that is it may come from the person with whom you have entered into an agreement, or it may come from any other person. That is also absolutely fine. It should be there. It is essential. Okay, come on, the next one. Next one is Mr. Pramod, by a deed of gift, transferred a certain property to his daughter with the direction that she should pay an annuity to her sister Y. You understood, friends? See, if we understand this, Mr. Pramod transferred a property to his daughter X with the direction that she should pay annuity to sister Y. You understood? So property was transferred, and in return daughter will pay annuity to Y. Okay, so yes, so there was a promise here. So property was transferred to daughter X. So X executed, writing in favor of Y, agreeing to pay annuity. That is, Y made a promise that yes, I will be paying you annuity, don't worry. Annuity means annual expenses. Okay. Now later on what happened? Later on X refused to pay the amount. X made a promise, but then X refused to perform her promise. X has done the breach. X has done the breach. X refused to pay the amount to sister. Okay. So now you tell me, X has done the breach. This agreement was breached because she has taken the property. Now therefore she has to pay annuity, but she did the breach. Can Y sue X? What do you think? See, can you see that X refused to pay to Y? What do you think? Options are: she is not bound to pay the promise amount as the promise made by her father on behalf of her, which is not valid. She is not bound to pay the promise amount as the condition automatically vanishes after the death of the father. She is bound to pay only the reasonable amount as she was not a direct party to the contract. She is bound to pay the promise amount because consideration need not necessarily move from the promisee. Can you see here, friends? See, in this, Mr. X, daughter X told that I am not getting anything in consideration from Y. I am not getting any consideration from Y. Right? I am not getting any consideration from Y. So, what to do? Therefore, I am not going to give any annuity. So, what do you think? Is it okay? So, answer is no. Because as per the features, consideration may come from the promisee or any other person. Obviously, X daughter has received consideration from Pramod ji. Yes or no? Yes. So, she is not getting consideration from Y, but she is getting consideration from another person. So, therefore, as the consideration was not missing, it is a valid contract. And yes, she is bound to pay the promise amount. So option D is the answer. Again, this is connecting with the case law Chinaya versus Ramaya. Come on, next one. A promise to pay time barred debt must be dash. Come on. What is time barred debt, friends? You know, friends, as per the limitation rule, as per the limitation act, what the rule is? The rule says that if there is a contract and if there is any breach in the contract and you want to sue the opposite party, you want to take action. So the act says that, limitation act says that there is a limitation time to take action. Once the limitation time period is over, you cannot do anything. So what is that limitation time? Do you know, friends? Anyone can answer this. What is that limitation time period? So answer is 3 years. 3 years over, everything over. Yes or no? Once the 3 years is over, then everything is over. Yes, so here, this is also one of the exceptions of no consideration, no contract. That is, promise to pay for a debt which is barred by limitation. So come on, that promise to pay the debt which is barred by limitation is a valid contract? Yes, it is a valid contract. So such type of promise must be dash. Oral promise, implied promise, it in writing and signed by the debtor or his authorized agent, none of the above. So obviously the promise must be in writing and it should be yes. So answer is C. So C is the right answer. Yes, we go to the next one. Contract made on account of love and affection should be dash. Yes, I hope you remember this. Today we did this topic out of natural love and affection. This is again one of the exceptions of no consideration, no contract. I told you husband, wife both got separated. Husband made a promise to pay, yes, expenses to wife, monthly expenses to wife. So what is consideration for husband? Nothing. Husband is not getting anything in return. Yes. So there is no consideration. Still, is that promise a valid contract? Yes, it is a valid contract if conditions are satisfied. There are 4 conditions. Come on. It should be in writing. That promise made by husband should be in writing, signed by the party, registered under law, and there should be love and affection. These 4 conditions should be satisfied. So here, can you see the 4 conditions? Yes. What it says? So contract made on account of love and affection should be dash. Come on, what do you think? It should be dash. So expressed in writing only, positive promise, oral promise, written and registered under law. So obviously answer is D, written, registered, and it is obviously love and affection which is given in the question itself. So then it makes a valid contract because it is an exception of love and affection. It is an exception of no consideration, no contract. Right? Yeah. So next one. Next question is, if a creditor does not file a suit against the buyer for recovery of the price within 3 years, the debt becomes dash. Come on, just now we have discussed time barred debts, if you remember. If you want to take action, if you want to sue anyone, you need to take action within the limitation time period only. What is that limitation time period? That is obviously 3 years. 3 years over, everything over. Now you cannot take any action, right? So friends, if you can see here, creditor does not file a suit against the buyer for recovery of price within 3 years. So obviously 3 years over, everything over. So such transaction becomes time barred transaction. So answer is obviously A, it is a time barred and hence it is now irrecoverable. Right, I hope this is clear. Next one, as per Indian Contract Act 1872, promises which form the consideration or part of the consideration for each other are dash. This question, yes, this question is nothing but a definition of reciprocal promises. Section 2, subsection F. Yes, if I give you example, like see there are 2 parties, A, B. There was a contract between these 2 parties. Okay, in this contract, A promises B promises to supply goods. Promises to supply goods. This is one promise. Why A made this promise to B? Why A made this promise to B? A made this promise to supply goods because B is making another promise in return. B made a promise to make the payment. Yes or no? This is another promise. Why B agreed to make the payment? Because B is getting another promise in return. Why A made that promise? Because A is getting another promise in return. So can I say both this promise are forming consideration for each other? Both of these promises are forming consideration to each other. Such promises are called as reciprocal promises. These are called as reciprocal promises. I hope this is clear. So option A is the answer. That is, promises which form consideration or part of consideration for each other is reciprocal promises. Yes, let's go to the next one. So friends, now the next question says, yes, next one. Mr. Jackpot is a patient in a lunatic asylum, but occasionally he is of sound mind. And during that time, he entered into a contract with Mr. Bill. As per Indian Contract Act 1872, identify the nature of contract. Come on, you saw here what it is. Mr. Jackpot is a patient in lunatic asylum. Means he is not in his senses. Insanity. But occasionally he is of sound mind. Sometimes he is of sound mind, he is proper. And during that time, which time? When he was of sound mind. Okay. He entered into a contract with Mr. Bill. So as per Indian Contract Act, identify the nature of contract. Come on, is this contract valid? Firstly, I would like to tell you, see this topic. This is the topic capacity of parties. You know, this is also one of the essential elements for a valid contract. You know, every person cannot enter into a contract. Yes, there are few parties. You know, parties must be competent to contract. Parties must be competent to contract is an essential element for a valid contract. So who all cannot enter into a contract? First is minor, but there are rules of minor. Then second one is person of unsound mind, the point which we are talking about. Third, persons disqualified by law, under which there are 5 points: alien enemy, convict, insolvent, foreign sovereign diplomatic staff, then corporation and company. So all these are the people who cannot enter into a contract, but there are rules also. So if we talk about this particular point, you can see here the person is of unsound mind. So technically he is not eligible to enter into a contract, right? But friends, what about a person who is of sound mind sometimes and who is of unsound mind sometimes? Person who is of sound mind sometimes and sometimes he becomes of unsound mind. Like here you can see Mr. Jackpot. Occasionally he is of sound mind and sometimes he is of unsound mind. Can you enter into a contract with such a person? So answer is yes, if you enter into a contract with such person at the time when he is of sound mind. At the time when he is of sound mind, it is a valid contract. And if you enter into a contract with such a person when he is of unsound mind, contract is void. Okay. So here you can see he has entered into a contract when he is of sound mind. So obviously this is a valid contract. So option A is the answer. Superb. Let's go further. Next is capacity to contract has been defined in dash. Come on, capacity to contract, that is capacity of parties, is defined under dash. So friends, answer is what? Come on, section number 10, 11, 12, 25. So obviously answer is section number 11. Capacity of party. Just now we have revised that who all cannot enter into a contract. So that is given under section 11. We go to the next point, next question, that is minor's liability for necessaries supplied to him dash. So friends, firstly, as I told you, the point minor. You know, minor is not competent to contract. If you enter into an agreement with minor is void ab initio. But there are rules of minor. In the rules, one of the rules is, you know, minor's property, see, minor can never be made liable for anything, right? So there is a rule that minor's property is liable for the payment of necessaries. Minor's property is liable for the payment of necessaries. Firstly, what are necessaries? Friends, necessaries refers to 5 things: food, clothing, shelter, health and education. Food, clothing, shelter, health and education. 5 things. These all are necessaries. Getting my point? Yes. So friends, the point is, the rule, as I told you, minor's property is liable for the payment of necessaries. Minor is not liable, minor's property is liable. So if you see this question, that is minor's liability for the necessaries supplied to him dash. So what is the answer? Arises after he attains majority? No. Remember this thing, huh? See, agreements which are made in minority cannot be ratified in majority, cannot be approved in majority. So A is not the right answer. Then, is against minor's property only? Yes, this is the answer. As I told you, minor's property is liable for the payment of necessaries. Then, minor's liability does not arise at all. So it arises. So option number C is not the right answer. And last one, arises only when minor promises to pay for them. So that is also not the case. So option number B is right answer. Next one, 2 persons have the capacity to contract dash. 2 persons have capacity to contract dash. If both are of unsound mind, obviously no. If none is disqualified from contracting by any law to which he is subject. If both have attained the age of majority, and all of the above. Come on, if both are not unsound mind. If both are, none of the parties are disqualified by law. If both have attained the age of majority. So what is the answer? Answer is all of the above. D is the right answer. As I told you, minor, person of unsound mind and person disqualified by law. These people cannot enter into a contract. So here you can see both should not be of, you know, they are not unsound, means they are of sound mind. They are not disqualified and also they have attained majority, means they are not minor. So answer is D. Next one, a minor child was provided treatment in hospital by a doctor. Okay, minor child was provided treatment by a doctor in a hospital. Hospital can recover his reasonable expenses from dash. Come on. See, again here you can see a minor was given what type of services? Minor was given services, that is one of the necessaries. As I told you, there are 5 necessaries, yes or no? Food, clothing, shelter, health. Here we are talking about health, right? Yes. So the minor was given one of the necessaries. So can hospital recover this money from minor? No, because minor is never ever liable. Can hospital recover money from minor's property? Yes. So hospital, doctor can recover his reasonable expenses from dash. Can't recover as there was no contract. Can recover from minor personally. Can recover from guardians. Can recover from the estate of minor as it was the necessary of life supplied to him. So option D is the right answer, that is can recover from the property of minor as it was one of the necessaries. I hope this is clear to everyone. Yes, we go to the next one, that is which of the following types of persons are not disqualified from contracting? Who are not disqualified? Come on. Foreign sovereign diplomatic staff disqualified? Yes. Alien enemy disqualified? Yes. Convicts disqualified? Yes. So who are not disqualified? So answer is none of the above, because all the 3 are not competent to contract. I told you, right? See, minor cannot enter into a contract. Person of unsound mind cannot enter into a contract. That in person disqualified by law cannot enter into a contract. And in person disqualified by law, you can see there are 5 parties. That is alien enemy, insolvent, convicts, alien enemy, foreign sovereign diplomatic staff. That is also there. So all of them are disqualified. Therefore, answer is D. See friends, whenever you see a question, always you should see first whether there are words like not disqualified, not, un, because many times we see the question and we don't read it properly, and it seems like question is very easy, and we mark any right answer in hurry, so it may lead to negative marks. So please understand that. Okay, let's go. Next one. Next is free consent related topics. So what is the question? Next question is, where one party is in a position to dominate the will of another and uses his position to obtain the consent of other party, the consent is said to have been obtained by dash. See friends, here we are talking about free consent. Let us revise this. See, the free consent is one of the essential elements for a valid contract. Free consent is an essential element for a valid contract. Only consent is not enough. Consent must be free consent. Means a person should enter into a contract by his own will and not because of any pressure. If a person enters into a contract because of any pressure, obviously that contract is not valid. Okay, so here you can see a person who is at a position, he is creating the moral pressure on another party to enter into a contract. Obviously, person is not giving any type of threat. It is not a threat. But by the use of that position, he is creating the moral pressure on another party. Right? And this party is having no option but to listen to him, but to enter into a contract. Are you getting my point? Tell me. This party entered into a contract? Yes. He gave his consent? Yes. But his consent was not a free consent. It was not a free consent. Why? Because he entered into a contract just because of that moral pressure, the mental force. This is a situation of undue influence. This is undue influence. Remember one thing, whenever you see any type of, use of the position, dominating the will of another, you see the word moral pressure, then in that case you should mark undue influence. Okay? Yes. So the next one is, X threatens Y, I shall kill your son if you do not contract to sell your land. I will kill your son if you don't enter into a contract to sell your land. So now you can see here, X is giving a threat to Y. Yes or no? X is giving a threat to Y. For what? To kill his son. Right? If you do not enter into a contract to sell your property. So why did Y entered into a contract? Why did Y entered into a contract? He was having no option. This is what? This is a threat. Right? So friends, whenever one person forces another person to enter into a contract by giving threat, direct or indirect threat, it is nothing but coercion. This is a coercion. So coercion is the answer. Again, you can see in this case what happened, friends. In this case, party is entering into a contract, but party is giving his consent, but party is not giving his free consent. Therefore, there is a problem. Right? Yes. So we are done with 40 questions. Yes, 40 more to go, covering this chapter. Yes. So are you ready? Let's go. Let's continue. So friends, the last 2 questions, if you see, one was the question related to undue influence, one was the question related to coercion, right? So see, whenever you enter into such contracts, you can see the person is entering into a contract because of that force, because of that, moral pressure or threat. So are these contracts valid? No, because free consent is missing. Are these contracts void? No, these are not valid, these are not void. So what are these contracts? These contracts are voidable. You know what are voidable? Voidable means right now the contract is not valid, not even void. It may be valid, it may be void. Right now it is nothing, it's voidable. Because it depends, it is at the option of the other party. It is at the option of aggrieved party. Means whatever has happened, now if the suffering party is having no objection with whatever happened, so contract is valid. But if party is having objection, so contract becomes void. So that is called as voidable. Okay. So let's go. So the following will make a contract voidable. Come on, what will make a contract voidable? I told you just now, I explained you the meaning of voidable. So come on, fraud is voidable? Yes. Coercion is voidable? Yes. Undue influence is voidable? Yes. So what is the answer? All of the above. Remember one thing, friends, all the points of free consent like coercion is voidable, undue influence is voidable, fraud is voidable, misrepresentation is also voidable. These four, all the four are voidable. Okay. Yeah. Next. If both the parties are under mistake as to fact, mistake of fact, essential to contract, then the contract is dash. Come on, here we are talking about bilateral mistake of fact. You know, friends, there are two types of mistake. One is mistake of law, another is mistake of fact. Mistake of law, mistake of fact. Okay. Now see, friends, whenever we talk about mistake of fact, there are two cases. Number one is, two cases, right? Number one is bilateral mistake, unilateral mistake. In the given question, see, bilateral means both the parties. Okay, unilateral means only one party. So here they are saying that, friends, if both the parties to contract are under mistake, like for example, if today I promise to supply you goods of USA, I promise to supply you goods of USA. So today I told you that I promise to supply you goods of USA, but where are the goods right now? Goods are on the way, goods are coming in a ship from US to Mumbai. I promise this to you today. Okay. So there is a contract between us. There is a contract between these two parties. So contract is done. Okay. But you know what was the fact? Fact means the truth. What was the fact? The fact was the contract, the goods which we are talking about, that ship in an accident, the ship already, yes, the ship already met with an accident few days ago and all the goods drowned. So now there are no goods, there is no ship. You know, this happened few days ago, not now, few days ago, and still we are entering into a contract today for the same goods. Tell me, is this party aware about the fact that the ship met with an accident? No. Are you aware about with that fact that ship is no more? No. So can I say both the parties are under mistake? Yes. Both the parties are not aware about what? Both the parties are under mistake of what? Mistake of law or mistake of fact? The parties don't know the fact. Getting the point? So both the parties to contract are under mistake of fact. It is called as bilateral mistake of fact. So what do you think? What about this contract now? Come on, ship is not going to come now. So contract is void. This contract is void. So remember one thing, because ship is not going to come. So if ship is not going to come, I am not going to deliver the goods. Can you sue me? No, because it is not enforceable by law. Because both the parties were not aware about the fact. So it is bilateral mistake of fact and answer is void. Easy? Come on. Next. A student agrees under a pressure to gift his entire property to his education guru. Such contract can be set aside on the grounds of dash. Come on. You understood? A student agrees under pressure to transfer his property to his education guru. Means a student is transferring his property to his teacher under a pressure. Okay. And what do you think? Such a contract is dash. What is this about? So obviously here we can see teacher is at a position and teacher is creating the moral pressure on student to enter into a contract to transfer the property, and student is having no option but to listen to him. So student entered into a contract. So obviously this is a case of what? Is this a case of threat? No. Is this coercion? No. What is this? This is moral pressure, and therefore this is undue influence. So friends, what do you think? The contracts under undue influence are what? Valid or void? Valid or void? What do you think? Valid or void? Come on, tell me. So answer is, it is voidable. It is not valid, it is not even void, it is voidable. And you know the meaning of voidable, right? May be valid, may be void. It is at the option of aggrieved party. Okay, fine. Come on, let's go. Next one. When a person asserts something which is not true, okay, person which asserts something which is not true as true, but he believes it to be true, okay, his assertion amounts to dash. His assertion amounts to dash. What is this? See friends, if a person, you know what is the difference between fraud and misrepresentation? However, both are voidable. But what is the difference between fraud and misrepresentation? You know, the fraud means one party is having intention to cheat the other party. Okay? Yes, intention to cheat. And misrepresentation is innocently done. Misrepresentation means a party is not having intention to cheat the other party. Innocently done. So it is misrepresentation. In the given question you can see a person asserts something which is not true, but he believes it to be true. Like if I give you some information which is not true, but according to me it is true. Come on. A person makes a statement, false statement, but he believes it to be true. So is this fraud? Is this fraud? Here, can you see the intention to cheat? No. There is no intention to cheat. This is innocently done. Right? Because person is not having any intention to mislead the other party. He is innocently making this statement. So therefore, this leads to what? This leads to misrepresentation. Because he believes it to be true. According to him, it is true. Okay. Yes. Next one. In order to sustain an action for deceit, there must be proof of dash. Come on. Whenever you want to take action for deceit, deceit means cheat. Okay, there must be proof of dash. Come on. When we talk about cheat, when we talk about deceit, so very simple. Here we are talking about fraud, obviously. We are talking about fraud, right? Generally, right now I told you, whenever a person is having intention to cheat the other party, it is fraud. So answer is option C, fraud. Come on, next. Y sold some goods to X. Y sold some goods to X, which Y believes to be of a superior quality, whereas they are of inferior quality. It is a case of dash. Come on, have you understood this, friends? Y sold some goods to X. Y sold goods to X, which Y believes it to be of superior quality, but actually they are of inferior quality. So can I say Y is selling the goods to X, okay, which Y believes it to be of superior quality? Means what? Can I say he is innocently doing it? Yes. Can you see there is any intention to cheat? No. Correct? Yes. So it is a case of dash. It is a case of misrepresentation. Perfect. Next. In case of dash, agreement is void. Come on, in which case agreement is void? See, in case of coercion, that is threat, agreement is what? Voidable. In case of misrepresentation, agreement is voidable. In case of fraud, it is voidable. In case of mistake, it can be void. Yes. So option A is the answer. mistake. As I told you just now, bilateral mistake of fact. So bilateral mistake of fact is what? Bilateral mistake of fact is void. Okay? Yeah, coercion is again voidable. It is by giving threat if we enter into a contract. So by giving threat, if I take your property, if you sign the agreement, in such case what will happen? It is voidable. It depends on the objection of the aggrieved party, suffering party. If you have objection with whatever happened, it is void. If you have no objection, it is valid. Right? So answer is A. Next, ignorance of law is no excuse comes under dash. Ignorance of law, are you getting my point? Ignorance of law is no excuse comes under dash. See, you tell me one thing. Friends, if you commit any act, obviously act of contract, agreement, if you do something which is a mistake in the eyes of Indian law, okay, if you do something which is a mistake in the eyes of Indian law, tell me, are you excused for doing such an act, or you will be punished? Come on, if you do something which is a mistake in the eyes of Indian law, it is excusable or it is not excusable. What if you say, I was not aware about this law? So if you were not aware, you should have been aware. Yes or no? See, there are two types of law for us. One is home law and another is foreign law. If you do something which is a mistake as per Indian law, that is home law, obviously it is not excusable and it is valid. Valid means enforceable by law, means law will punish you, right? So here you can see the same thing. Ignorance of law is no excuse comes under mistake of law of land, mistake of foreign law, unilateral mistake, bilateral mistake. What is the answer? Come on everyone. What do you think? Answer is A. Mistake of law of land, that is mistake of Indian law. If you do anything which is a mistake in the eyes of Indian law, it is not at all excusable. Okay, come on, next. Next is active concealment of fact. Concealment means what? Concealment means hiding. Okay, so active concealment of fact is associated with which one of the following? Come on, hiding the fact. Active hiding the fact. Active concealment. What if you purposely hide something? Come on, it is what? Is it misrepresentation? No, because misrepresentation is innocently done. Is this undue influence? Is this moral pressure? No. Is this mistake of law, mistake of fact? No. So what it is? It is a fraud. Because here you can see the intention of party. What is the intention? Intention is to cheat the other party. You are purposely doing it. Purposely you are hiding it. Right? So C is the answer. So now we have reached the half century. Yes, question number 50. The cancellation of contract due to impossibility of performance is dash. So friends, again we need to remember essential elements for a valid contract. You know friends, performance must not be impossible is an essential element for a valid contract. I repeat, performance must not be impossible. Because if you enter into an agreement which are impossible, performance is impossible. So impossibility agreements are obviously void. So they are not a valid contract, right? So here we are saying that if you enter into a contract, performance of which is impossible, so obviously contract is void. Okay, so what does it call? Obviously contract is void, but here in the question they are not asking us the effect of such contract. Yes, what are they asking? They are asking which one of the following options is suitable in the given question. So friends, answer is B, that is frustration of contract. What does it mean? Frustration of contract. Yes, the impossibility of performance of contract is also called as frustration of contract. Please note down this. Okay, so option B is the answer. Frustration of contract. Come on, next. 51. X owes 15,000 to Y. X owes 15,000 to Y. X pays 12,000 in full and final settlement of the outstanding due. This is a case of dash. This is a case of dash. Now what is this? See friends, you know, like the terms here, X owes 15,000 to Y, but he pays how much? He pays 12,000 in full and final settlement. So friends, there is a term that is called as remission. You know, remission means what? Remission means to remit. Okay, it means to remit. Now what is this remit? Remission means acceptance of lesser amount in full and final settlement. Acceptance of lesser amount in full and final settlement. Yes. So friends, see, if like I am liable to pay you 15,000 rupees after a certain period of time, and if you make an offer, if you tell me that if you pay now, like you can know trade discount, like if you make an offer, you tell me that if you pay now, instead of 15,000 you have to pay only 12,000, but if you pay on due date you have to pay the entire 15,000. So what I did, I paid 12,000. So friends, tell me, if I paid 12,000, are you accepting the lesser amount? Yes, you are accepting a lesser amount. You are accepting a lesser amount in full and final settlement. You are accepting a lesser amount in full and final settlement. You know, this is called as what? This is called as remission. If I repeat the other options, you know, the first option, novation, means substitute. Option B, you can see alteration, changes in the contract. Option D, you can see cancellation. And option C is remission, that is to accept the lesser amount in full and final settlement. So here you tell me, here, if this amount of 12,000 is paid, if X pays 12,000 rupees, that means can I say Y has accepted 12,000 rupees in full and final settlement? Yes. So it is a case of remission. Okay, let's go. So once X pays the 12,000 amount, will X be liable to pay the remaining 3,000 later? No. Once Y accepts the lesser amount, then the contract is discharged by remission. Okay. Next, when the parties agree to cancel the contract, it is called as dash. When party agrees to cancel the contract, it is called as dash. What do you think? Cancellation. So again I repeat, remission, just now I explained you, it means accepting the lesser amount in full and final settlement. But in the given question they are talking about cancellation. Then novation means to substitute. Alteration means to do the changes. What is rescission? Rescission means to resign. It means to resign, it means to cancel. Okay, it means to what? Cancel. So answer is option B, that is rescission, to cancel. Come on, once again, the term novation means dash. Come on, you can answer this now. I have already explained you novation so many times. What is novation? Amendment to the terms of contract, substitution of contract with a new contract, remission of contract or rescission of contract. What it is? So obviously remission means to substitute contract with a new contract. Next, which one of the following is not correct? Which one of the following is not correct? Okay, let's see one by one. The maxim quid pro quo means lawful consideration. Is this correct? Yes, this is correct. Quid pro quo refers to consideration. The person entering into a contract must be major and of sound mind. This is also correct. The maxim consensus ad idem means that the parties to contract must agree upon same thing in the same sense. Even this is correct, right? Then consent is not deemed to be free when it is, yes, when it is, initiated by misrepresentation. Come on, which of the following is incorrect? What is the answer? So first one is obviously correct. Quid pro quo refers to consideration. Then person entering into a contract must be major as well as of sound mind. Then consensus ad idem means agree for the same thing, same time, same sense, right? Then consent is not deemed to be free when it is by misrepresentation. So option D is your answer to the given question, because they're asking you which one of the following is not correct. Because you know, misrepresentation means what? It totally means the different thing. Misrepresentation means innocently done. So it is the different meaning for misrepresentation. So answer is B. Next, on the valid performance of contractual obligation by party, the contract dash. See, once the contract is formed between two parties, what is the next step? Next step is performance, right? So once the contract is formed, once both the parties have already performed their respective promises, when the parties have already performed their obligations, can we say contract is over? Yes. Contract is discharged? Yes. So answer is A. Contract comes to an end. Contract is discharged. Any doubt in this? So option A is the answer. Next is supervening impossibility is discharge of contract by dash. What is supervening impossibility? So friends, let me tell you this. See, firstly, you know, performance of contract must be possible, right? Performance of contract must be possible. If you enter into an agreement, performance of which is impossible, it is absolutely void. But you know, there are two types of impossibility. One, when you enter into a contract, it is impossible from the beginning. This is one type. That is impossibility existing at the time of contract. Come on, impossibility existing at the time of contract means it is impossible from the beginning. Such agreements are void agreements, that is void ab initio. But the another type is supervening impossibility. See, remember one thing, the first one which I told you, that was impossible from the beginning, right? That is void from the beginning. At the time when you were entering into a contract, from the first day itself it is void, it is impossible. But the second category is what? Second category is supervening impossibility. That is, at the time when you enter into a contract, that time performance was possible. At that time performance was possible. Impossibility arises after formation of contract. Impossibility arises after formation of contract. Such type of impossibility is called as supervening impossibility. Like for example, if we enter into a contract right now, whatever agreements we have done, contract we have done, performance is possible. Like for example, if I want to buy your business, liquor business. So if I want to buy a liquor business right now, it is possible, no problem. We have entered into a contract. Now after entering into a contract, suppose you have made a promise to me that I will transfer all the papers, I will transfer the business in 3 days in my name. Same thing I told, okay, I will make the payment in 3 days. So contract is already done. Now after formation of contract, there was change in law. Law changed. What is the new law now? Suddenly there was change in law. The government made the announcement that liquor business, nobody can do liquor business now in this country. Liquor ban, completely ban. So now tell me, because of this change in law, can I buy your business now? No. Can we continue this contract? No. Tell me, at the time when we entered into a contract, that time the performance was possible? Yes. That time can I buy your business? Yes. But now can I buy your business? No. Now it has become impossible for me to continue my promise. This is called as impossibility of performance due to a supervening impossibility. So what is supervening impossibility? Supervening impossibility means the impossibility arises after formation of contract. Right? So what is the right answer? Come on everyone. Yes, answer is impossibility arising after formation of contract. That is option D is the right answer. Superb. Come on, next. I hope everyone is learning, everyone is revising. Are you all here? Yes. Let's continue, Yodha. Next one is, each party to contract is bound to perform as part of obligation. True. Every party have to continue the obligation. They have to fulfill their promise, right? After the parties have made the performance, the contract comes to an end. Correct. Once the party perform their obligation, contract is over. Contract comes to an end, right? In such case, contract is said to be discharged by dash. What is the reason for discharge in this given case? So, is it called as discharge by breach? Is it called as by impossibility of performance? Is it by agreement and novation? Is it by performance of contract? Come on, by what reason you can say contract comes to an end in the given case? So in the given case, it is very simple. The parties entered into a contract, right? Then parties have already performed their respective obligations. Both parties have performed their obligations. Okay. So if the parties have already performed their obligations, contract is over due to what? Contract is over due to performance of contract. Because parties have already performed. Okay, yes. Then we are reaching to the next part of the act, that is breach of contract related questions. Firstly, friends, you tell me, what is breach? What is breach of contract? You know, once the contract is formed, the next step is performance. But if any of the party refuses to perform his obligation, or if any of the party fails to perform his obligation, it is called as breach. It is called as breach. Okay? Yes. So whenever there is a breach, what can you do? What do you think? Let's say, for example, if one party refuses to perform, can you sue him? If one party refuses to perform, what do you think? If one party refuses to perform, is it possible that the other party has suffered some loss? Yes, it is possible that other party has suffered some loss. So can other party sue him for the damages? Yes, other party have right to sue for damages. One thing. Second, if one party refuses to perform, if one party does the breach, now, is it okay if you don't perform your obligation? Can you cancel the contract? Come on. If one party refuses to perform, can you cancel the contract? Can you do this rightfully? Do you have right to cancel the contract? Yes. Can I say this right to cancel is because of his breach? So, can you sue for damages? Yes. Can you cancel the contract? Yes. Cancel means rescission. You can cancel the contract also. And in few cases, you can also sue the person for specific performance. You can sue the person for what? Come on, tell me. Yes, correct. Specific performance also. Now friends, tell me, what is specific performance? See, you can cancel the contract if the other party does the breach. You can sue for damage, right? And you can also ask for specific performance. What is it? So friends, answer is, concentrate everybody. See, suppose if I enter into a, I have a very big hotel. I have opened a 5-star hotel in Mumbai. Okay. So to entertain all my guests, I have hired one very well-known singer also. Let's say any like Mr. Badshah or anyone. I have entered into a contract with the singer. Now there is a contract of 5 years. That means he is going to perform in my hotel for 5 years, right? And I am going to make payment to him. Okay. Now what happened? What he did after 1 year, he refused to perform. He said that I will not continue the contract. I will no more perform in your hotel. So he is refusing to perform. But then I told him that I will sue you for the loss. I will sue you for the damages. He told, okay, sue me, no problem. I am ready to pay the damages. Friends, he is ready to pay the damages. But friends, you tell me, whatever damages he pays me, whatever amount he pays me. See, what I want is, I want the singer. I want that particular singer only. Because my hotel business is running because of his performance. Are you getting it? So whatever amount he pays me, whatever 1 crore, 2 crore, whatever he pays me, will I get the same singer? No. So in this example, can you see the amount what he's paying me in the form of damages, in the form of compensation, that is not going to give me relief. Is it going to give me relief? No. So what I want? I want performance only. I want specific performance. I want him to perform the contract. Yes. So what I will demand? I will demand to court, okay, please give me specific performance. So this is also one of the remedies in law. Like, firstly, listen to me very carefully. Specific performance is not given every time. You can demand specific performance only and only and only when money is not the remedy. When money is not going to give you relief, then you can demand specific performance. Otherwise, you cannot demand. It is not in the every case, right? But obviously, in case of breach, this is also one of the relief. Yes. So therefore, what is the answer? Come on, in case of breach, can you cancel the contract? Yes. Can you demand for damages? Yes. Can you demand specific performance? Yes. So answer is all of this. Because the question is, in case of breach of contract, which of the following remedy is available to the aggrieved party? Aggrieved party means suffering party. So all of these remedies are available. Okay, we move to the next one. Breach of contract on the due date is known as dash. Come on. Breach of contract on due date is known as dash. What do you think? See friends, there are two types of breach. One is anticipatory breach and another is actual breach. What is anticipatory breach? Breach means, refusing the party to perform, breaking the promise basically. So anticipatory breach means whenever party refuse to perform before the day of performance. Like for example, if contract is to be performed on 10th of October, suppose, but party on 8th October itself, party refused to perform. Party said that, no, I am not going to perform. So party refused to perform before the day of performance? Yes. So if party refused to perform before the day of performance, it is called as anticipatory breach. And what if party refused to perform on the day of performance? If party refused to perform on 10th itself, on the day of performance, it is called as actual breach. Okay. So friends, here, what is the question? Come on. Breach of contract on the due date is what? Anticipatory, actual, both, none. So obviously answer is actual breach. So option B is the right answer. Next, exemplary damages are otherwise called as dash. Exemplary damages are otherwise called as dash. Friends, whenever there is a breach, we sue for damage, right? But there are different types of damage. The types of damages generally you don't have in your CSEE syllabus, but it is a part of Indian Contract Act. So we have added that also in this question answer series, Yodha series, right? So here you can see exemplary damage. Firstly, what is exemplary damage? Exemplary damage means damage to the reputation. Damage to the reputation. If we enter into a contract and if I don't perform my obligation of contract, if I do the breach, and because of my breach, you suffer a damage to your reputation. Because of my refusal of performance, there is damage to your reputation. Can you sue me for the damage? Yes. So in that case, you can sue me for what type of damage? It is called as exemplary damage, vindictive damage. Yes. So these are the different names for damage to the reputation, that is exemplary damage, punitive damage, vindictive damage. All these are same. All the three talks about what? Damage to the reputation. Okay. So it is otherwise called as what? So answer is both A and B, as it can be called as punitive also, vindictive also. Okay. Come on, the next one. So friends, now last 20 questions. Each and every question is important. Everyone. I hope this is Clear to everybody? Yes, I have one more suggestion for all of you. What you can do is, you can on this YouTube channel, you can see our previous series also. All the series for CSEE, every attempt is very useful. And as you know, there is nothing like major changes in CSEET syllabus except current affairs. So you can see our previous series also. Like we have Ramban series, you can see on this YouTube channel for CSEET students. Then you can see the Yodha 1.0, Yodha 2.0. This is Yodha 3.0. So you have time, please go and watch. Each and every video is useful for you. Okay, yes, on this channel you can see only content and no nonsense at all. Okay, let's go. So friends, what is the next question? The court in a case may order specific performance of the promise made by a party to a contract dash. Come on friends, what is the topic? It says that in a contract, court may order what? Specific performance. Do you remember specific performance? I told you just now. In the previous questions, I have explained you specific performance. Example which I took, I have a hotel, I have hired a singer. Right? So tell me, can you demand specific performance every time? No. You can demand specific performance only and only when money is not the remedy. Only and only when money is not the remedy. Getting the point? Yes. So friends, court can order specific performance dash. When contract is voidable? No. When the damages are adequate remedy? When defaulting party is not ready to pay the damages? When damages are not adequate remedy? What is the answer, friends? Come on, I want you to answer this question. Tell me what it is. Which is the right option? You can demand specific performance when dash. Yes, you can recollect my example which I gave you recently about that hotel, singer, contract. Right? He was ready to pay the damages. But that amount, whatever he pays, was not remedy for me. So what I demanded? I demanded specific performance. So what is the right answer? Yes, so right answer is D. When the damages are not the adequate remedy. Yes, the money is not giving me the relief, then I can demand specific performance. Next question is, in case of anticipatory breach of contract, the aggrieved party may treat the contract dash. Come on. See friends, here we are talking about anticipatory breach. Okay. What is anticipatory breach? Anticipatory breach means when party refuse to perform before the day of performance. When party refuse to perform before the day of performance. Okay. Now see friends, what does it say? When party refuse to perform before the day of performance, it is called as anticipatory breach. Right? Like I told you that there was a contract between two parties, A and B. The contract was to be performed on 10th October. Okay. The contract was to be performed on 10th October. But you know what? The party on 8th October itself, A did the breach. A refused to perform on 8th. So you can see party refused to perform before the day of performance. So now tell me, can B sue A? Can B sue A? Yes, obviously B can sue A. But when can B sue A? Can B sue A on 8th October itself, or he will have to wait for 10th October? Can he sue on 8th October, or he will have to wait for the day of performance? That is, he will have to wait for the 10th October. What is the answer? So friends, answer is, if we see the effect of anticipatory breach, if B wants to sue A on 8th, he can sue on 8th. That is, B can sue without waiting for the day of performance also. And if B wants to wait, he can wait and he can sue later on also. So what is the answer? So friends, answer is, come on, the contract is discharged and bring an immediate action for damages. Contract is operative and wait till the day of performance arrives, or both A and B. So answer is C, both A and B. So option C is the answer. It is totally option of the party whether he wants to wait or not. Both the effects are correct. But if he wants to sue without waiting, can he do that? Yes, he can sue immediately also, or he can wait also, depends on him. Okay, so the next one. Which of the following statement is false regarding acceptance? So now acceptance topic, yes, so here we need to recollect the features of acceptance. So the first one is, here we need to see which of the following is false, okay? Come on. So acceptance must be communicated. Is it true? Yes, this is true. Acceptance must be communicated as per the features. Acceptance must be accepted by a person having authority to accept. This is also correct, that only authorized person can accept it. Acceptance must be absolute and unconditional. True, because conditional acceptance is a counteroffer. We have discussed this in the previous questions. Acceptance may be presumed from silence of offeree. Come on, if you make an offer and if the opposite party is silent, will this lead to acceptance? Obviously answer is no. So D is going to be the answer, because D statement is false statement. Okay, so D is the answer. Next, void agreements. Now in void agreements, the question says, an agreement which restricts a person's freedom to marry any person of his choice is against the public policy and therefore is dash. Firstly friends, you know there is a topic that is agreement declared as void. Agreements declared as void. You know there are few agreements which are declared as void. There are 5 agreements in Indian Contract Act which are declared as void. 5. That is basically, see, firstly, you know, if you want to enter into a valid contract, this is also an essential element. Yes, that is agreement. See, there are few agreements which are announced as void. So if you want to enter into a valid contract, so make sure you don't do a contract, you don't enter into an agreement which is already announced as void. Make sure about this, that you don't do an agreement which is already declared as void. Okay, see, there are 5 agreements which are declared as void. That is from section 26 to 30. That is agreement in restraint of marriage, agreement in restraint of trade, agreement in restraint of legal proceedings, agreement meaning of which is uncertain, and wager agreements. These 5 are declared as void. Okay, so yes, here you can see it is an agreement which is restricting a person to marry any other person of his choice. So basically this agreement is restraint of marriage. Restraint of marriage, and just now I told you 5 agreements, right, is what? Declared as void, and this is one of them, that is agreement in restraint of marriage. So no agreement can restrict anyone from getting married. If there is any agreement which restricts anyone from getting married, such an agreement is declared as void. So this is agreement in restraint of marriage, therefore this is void. Okay, so I hope this is clear. Yes. Next, in case of illegal agreements, the collateral agreements are dash. In case of illegal agreements, collateral agreements are dash. See, what are illegal agreements? Friends, suppose if I promise to deliver drugs today evening at your residence, we have entered into an agreement. I promise to deliver drugs at your residence today evening, 8 p.m. So please make the payment. So you have made the payment. Now in the evening, I refused to deliver the drugs. Means obviously I have committed the breach. Yes or no? I have committed the breach. So it's a breach. Can you sue me? Come on. Can you sue me? Firstly, tell me, what will you say? What? He's not giving me drugs. Will you say that? Will law force me to deliver drugs at your residence? Obviously no. Law is going to force me to deliver drugs. Law is going to tell me, hey, why you're not giving drugs? Come on, deliver right now. Obviously no. So this agreement is illegal, and illegal agreements are void. This agreement is void. Correct? But the question is about collateral agreements. Collateral agreement means any agreement which is connected to illegal agreement. See, illegal agreement is void. What about collateral to illegal? Collateral to illegal means any agreement which is related to illegal agreement. So friends, remember one thing, illegal agreements are void, collateral to illegal are also void. Okay, any agreement which is connected to illegal is also illegal, is also void. Suppose if I provide loan to someone to start some illegal business. So my agreement with that person is of loan agreement, right? But this is an agreement which is connected to an illegal business. So this is also void. Okay. So yes, illegal agreements are void and collateral to illegal are also void. So answer is B, void. Okay, next is agreement whereby one of the parties agrees to close his business for a consideration of a certain sum of money being paid by another party is dash. Now see friends, in this question you can see there is an agreement where one party promises to another party to close down his business. Okay, so one party enters into a contract with another party to shut down his business. So what is this? Come on. One party promises another party to shut down the business. What it is? And I'll give you money for that. Keep this 5 lakh rupees. Don't do business here. You accepted my offer. There is an agreement. Is this agreement valid? Answer is no. Why? Because as I told you, there are 5 agreements which are declared as void. 5 agreements which are declared as void. Are you getting the point? Yes. So friends, here you can see there is an agreement which is restricting someone from doing business. This is agreement in restraint of trade. An agreement in restraint of trade is declared as void. This is declared as void. So yes, this is void, because no agreement can stop anyone from doing trade. Come on, next. All void agreements are illegal. This statement is dash. All illegal agreements are illegal. All void agreements are illegal. True, false, what? See, firstly you tell me one thing. What about illegal agreements? Friends, if you enter into an illegal agreement, is illegal agreement valid? No. Illegal agreement is not valid. Illegal agreement is void. Void means not enforceable by law, right? Like just now I gave you example, if I have made a promise to deliver drugs at your residence, if I don't deliver the drugs, can you sue me? Will law punish me? No. It is not enforceable by law. It is void. So all illegal are void. Correct. All illegal are void. But friends, tell me, all void are illegal? Come on. All illegal agreements are void. True. Because all illegal are not enforceable by law. True. But tell me, all void are illegal? Answer is false. Firstly, friends, we need to understand what is the difference between void agreement and illegal agreement. Because you know what? See, illegal agreements are void. Okay. Means illegal agreements are not enforceable by law. Okay. Void agreements are again not enforceable by law. So what is the difference between both? So difference is, see, like agreement with minor. Agreement with minor is void. Yes. So if you enter into an agreement with minor, will law punish you? No, law will not punish you. It is just that you want to enter into an agreement, you do it. You do it. You enter into an agreement. It is not punishable. But if anything goes wrong, don't come to me. Don't come to us. That is what law says. Agreement with minor is not punishable. It is just void. It is not enforceable by law. That's it. Law will not support you. Law will not help you. That's it. But if you do illegal agreement, firstly, law will not support you. Means law will not force the party to perform the obligation. One thing. Plus law will also punish you. That is the difference. See, void agreements means it is not enforceable by law. Okay. But illegal agreement means it is not enforceable by law, plus it is punishable by law. Plus it is punishable by law. This is the difference. Okay, so tell me, if you deal with a minor, it is void? Yes. But is it punishable? Is it illegal? No. So therefore friends, all void are not illegal. Therefore this statement is false. This statement is false. I hope this is clear. Right? Yes. We go to the next part. Void contracts. Yes. Here the point says that a subsequent change in law will make the contract void because of dash. Yes. Subsequent change in law means there is change in law subsequently, later on, law changed. So that will make a contract dash void because of dash. Come on. You know friends, today in this session, I took one example that I want to buy your liquor business. So at the time when we entered into a contract, it was possible for me to buy the business. Right? We entered into a contract. But later on what happened? Friends, later on there was announcement by government, there was change in law. Law changed. Liquor business ban in the country. So now can I buy your business? No. Is it possible for me to buy the business? No. This has become impossible now. Tell me, is this impossible from the beginning? No. Is this supervening impossibility? Yes. Because impossibility arised after formation of contract. Later on, and reason was change in law. So what is the answer? Come on. Subsequent change in law will make the contract void because now it is impossible because of dash. Supervening impossibility, material alteration, commercial impossibility, partial impossibility. So friends, answer is supervening impossibility. So impossibility arises after formation of contract. Okay, so I hope you remember the example. Next is, we go to the next topic, that is now wagering agreements. What are wager agreements? Friends, wager agreements means agreements of betting. Betting, bet, yes. Like for example, if we enter into a betting agreement, like if I say that the India will win the match. Come on. Are you entering into a bet with me? So if you say yes, so we enter into a betting agreement. So this is called a betting agreements, wagering agreements, and you know wagering agreements is one of the agreement which is declared as void. I told you there are 5 agreements which are declared as void. 1. Restraint of marriage, restraint of trade, restraint of legal proceedings, agreement meaning of which is uncertain, and lastly wager agreements. If you enter into a betting agreement, wager agreement, it is declared as void. It is not enforceable by law, right? So let's see what it is. A agrees to pay 10,000 to B if it rains today. Wow, if it rains today. Otherwise B shall pay what? 10,000. So this is dash. Is this a gambling, speculation, game of chance, wagering agreement? So obviously this is a wagering agreement and it is absolutely void. Okay. So next question says, wagering agreements are nothing but ordinary dash. Betting agreements, quasi-judicial agreements, sale agreements, conditional agreements. So very simple, that is betting agreements. So again I would say it is declared as void. But remember one thing, wagering agreements are declared as void, but collateral to wager agreement is valid. Remember this thing, everyone. In the previous questions we saw there were illegal agreements. So illegal agreements are void, but collateral to illegal is also void. But in betting agreement, the wager agreement is void, but collateral to wager is valid. Remember this, okay? Next. So next topic is contingent contract. Friends, what is contingent contract? Very simple. It is a contract, performance of which may happen, may not happen. It is a contract, performance of which may happen, may not happen. Because the performance in this case depends on happening or non-happening of a future uncertain event. Yes, performance may happen, may not happen, because performance depends on happening or non-happening of a future uncertain event. Like for example, if I promise you, I will supply you the goods, I will supply you food grains if there is good rainfall this year. Now tell me, I am going to supply you food grains, is this certain? No. Is my performance certain? No. I may perform, I may not perform. It depends on what? It depends on the happening of event. What is the event? Rainfall. If rainfall happens, I will perform, I will supply you the goods. If no rainfall, no performance. Right? So can I say this is a contingent contract? Yes, because performance may happen, may not happen. Right? Friends, can I say I will perform if there is good rainfall? If there is good rainfall this year. So can I say my performance is conditional? Yes, my performance is conditional. So friends, always remember, in every contingent contract you will see performance is conditional. In fact, contingent contract are also called as conditional contracts. Here you can take example of insurance also. We take fire insurance, to indemnify ourselves from the loss due to fire. So if there is any fire, if fire takes place, insurance company will give us the money, damages. No fire, no performance. Contingent contract. So the insurance company is going to perform if fire takes place. So again, performance is conditional. So therefore, contingent contract is also called as conditional contract. Remember this. Okay, then we go to the next part, that is quasi contracts. What are quasi contracts? Friends, quasi contracts are not a contracts, but they are like a contract. They are not a contract, but they are like a contract. Here, the parties have no intention to enter into a contract, but still the obligation is imposed on a person which a person is bound to perform. Lawful obligation is imposed on a person which a person is bound to perform. Just because of the obligation imposed on a person, he is bound to do that. If he don't do, opposite party will sue. A small example, finder of goods. Suppose if I get something, I am not the owner obviously. If I get something, tell me, do I become the owner of this article? Do I become the owner of this article? No, I am not the owner. I am a finder of goods because I found this from somewhere. So what I did with this, I kept this at my place. Friends, tomorrow, remember one thing, finder of goods is never the owner of goods. Okay. So if the real owner of this article comes with the proof that this article belongs to him, tell me, I am under the lawful obligation to return this to the real owner. Will I have to return this article to the real owner? Yes. Am I bound to return this to the real owner? Yes. If I don't return it, will real owner sue me? Yes. Can you see here? I am bound to perform something. I have to do this. If I don't do it, opposite party will sue. Tell me, when this type of burden is imposed on a person? When this type of burden is imposed on a person? Obviously, when a person enters into a contract. When you enter into a contract, this type of burden comes on you that you have to perform your obligation. If you don't do it, party will sue. But in this given example of finder of goods, tell me, was there any agreement between me and the real owner? We entered into any type of contract? No. Therefore, it is not a contract, it is like a contract. We were not having any intention to enter into a contract, right? But still, the obligation is imposed on me by law that I have to return it, I have to do this. If I don't do it, party will sue. This type of burden to do something, it is similar to contract. It is like a contract. This type of obligations that I have to return it, this is called as quasi-judicial. This is called as quasi-contract. It is like a contract. This is, yes, quasi-contractual obligation which I am bound to perform. If I don't return it, real owner can sue me. It's quasi-contract, right? So, dash arises when obligations are created without existence of contract. I told you there is not a contract in real sense, but still obligation is imposed. This is naturally quasi-contract. Okay, fine. Next is contract of agency. Yes, you know this. There is one principal is agent who deals with the third party customers, right? Agent sell goods with the third party. Agent receives payment with the third party and all those things. So the question is, minor can be appointed as an agent. Can minor be an agent? So friends, as per the rules, minor, yes, can be an agent, but minor can be an agent only for profits. Only for profits. But the question is, can he become an agent? So answer is yes, he can become an agent. He can be appointed as an agent, but only for profits. Okay. So B is the right answer. Next, contract of agency may be created by dash. Contract of agency may be created by dash. Come on, agency. This is about modes of creation of agency. You know, agency can be created by 4 ways. First, agency by actual authority. Agency by ostensible, that is estoppel and holding out. Then agency by necessity and agency by ratification. These are the 4 modes to create agency. So here they are asking agency can be created by what? So can agency can be created by express agreement, implied agreement? Yes. This 2, express and implied agreement, is nothing but actual authority. By ratification? Yes. So answer is D. All of the above. Okay. So yes friends. So next is contract of guarantee. How many? Yes. How many contracts are there in contract of guarantee? How many contracts are there? You know friends, what is contract of guarantee? Everyone, what is contract of guarantee? Here it says that, you know friends, always remember in contract of guarantee there are 3 parties. How many parties? 3 parties. 3 parties I am saying, not contract. See, there are 3 parties, A, B and C. Okay. Now suppose if A goes to bank because he needs some loan. So he was asking for the loan. Bank told A that you need to bring one guarantor for me. You need to bring one guarantor for me. Okay. So what A did? A asked C to become the guarantor. C agreed for the same and C gave guarantee for A. Okay. So now A becomes the debtor, banks become the creditor and C becomes the guarantor. Okay, that is surety. Surety means guarantor. So therefore his loan was passed by the bank. Bank approved the loan of 50 lakh rupees. So there was a contract of loan. Okay. So friends, this was one contract. Will there be any contract between C and bank also? That is, will there be any contract between the guarantor and the creditor also? So answer is yes. This will be contract of contingency. This will be a contingent contract. Why contingent contract? Because Mr. C is a guarantor. Yes or no? So can I say Mr. C will have to repay the loan if A don't repay the loan? Can I say performance of Mr. C is conditional? Mr. C will have to perform if A don't perform. So therefore this is a contingent contract. That is conditional contract. So that becomes contract number 2. Will there be any contract between A and C? So again answer is yes. This will be contract of indemnity. Contract of indemnity. What is this indemnity? See, suppose if C, the guarantor, have to repay the loan on behalf of A. If he has to repay the loan on behalf of A, in that case, obviously Mr. C has suffered the loss. Yes or no? Yes. So friends, if C has suffered loss, can he demand that money from A? Yes. He is going to say A, Mr. A, I paid loan on your behalf, so please indemnify me for my loss. So A will be indemnifier. C will be indemnified, indemnity holder. So therefore there will be contract of indemnity. Right? So sir, where is contract of guarantee? So friends, this is called as contract of guarantee. That is, whenever the three parties, that is debtor, creditor and surety. Whenever these three parties entered into a contract of contingency and contract of indemnity. I repeat, contract of contingency and contract of indemnity. This forms contract of guarantee. Okay. So come on, how many contracts are there in contract of guarantee? So answer is there are two types of contracts to form contract of guarantee, that is contingent contract and contract of indemnity. So A is the right answer. If they ask you how many parties are there, so there are three parties. Okay. Now the next question says a person who provides guarantee in a contract is called as dash. You can see the answer in this example only. Person who provides guarantee is called as surety. So yes, C is the right answer, surety. Next is A advances a loan of 5,000 to B. Okay, A gave loan to B. A gave loan to B. Okay, and C promises A that B, if B does not repay the loan, I will do so. So A gave loan to B and C has become surety. C gave guarantee that he is going to repay the loan. Mr. B is going to repay the loan. If he does not pay, I will repay. Okay. So friends, this is a contract of guarantee. Here B is dash. Come on. Here B is dash. Who is B? See, A gave loan to B. So A is a creditor, B is a debtor and C is a surety. Right? So answer is what? Who is B? So B is obviously principal debtor. Right? Because he is taking the loan. Come on, next is contract of indemnity. What is contract of indemnity? So very simple, as I told you, indemnity contract means, the word indemnity means compensate for loss, and contract of indemnity means it is a contract in which one party promises another party to indemnify him for his loss. One party promises another party that if you suffer any loss, I will compensate you for your loss. Such type of promise, such type of contract is called as contract of indemnity. This happens generally in case of insurance contracts. This happens generally in case of insurance contracts, yes. Like for example, if you buy medical insurance. So in that, obviously insurance company promises you that you pay the premium. In case if there is any medical expenses, we will compensate you for your loss. Yes or no? Yes. So that type of contract is called as contract of indemnity. So one party, that is, let's say insurance company, and Mr. A. Mr. A took insurance. What insurance? Medical insurance, which means insurance company promises to compensate him for his loss. Such contract is called as contract of indemnity. Okay. Now friends, in contract of indemnity, there are two parties you can see. One is the person who makes the promise to indemnify. Another is the person that is indemnity holder, that is indemnified, right? So here they say that in a contract of indemnity, the liability of the indemnifier means who? Insurance company. The liability of the indemnifier, that is promisor, is dash: primary, secondary, conditional, optional. Come on, what it is? The promise, can you see the promise is obviously conditional. That is, if A suffers the loss, then we will indemnify. If A does not suffer the loss, we will not indemnify. So therefore it is conditional. Okay, next is contingent contracts. Again, under Indian Contract Act 1872, dash is essential characteristic of a contingent contract. I have already explained contingent contract earlier, right? So what it is? Come on, the performance depend only on happening of event, future event. Performance depends only on non-happening of future event. Performance depends upon both happening as well as non-happening, none of the above. So answer is option C, because contingent contract is a contract. Performance depends on happening or non-happening of a future uncertain event. Performance depends on happening of event also. Performance depends on non-happening of event also. So that is contingent contract. Okay, and friends, the last MCQ for this today's session, Yodha series legal aptitude. Yes, along with last MCQ, that is, X enters into a contract with Y, okay, for giving a dance performance at a function. X agrees to give some dance performance with Y. He enters into a contract. Okay. Before the function starts, X dies. X dies. The contract can be performed by dash. Who can perform the contract? So here you can see there was a contract and one of the party dies. So in case of death, who can perform? In case of death, legal representative of party can perform, right? Lekin, friends, if personal skill and talent is required for performance, then who can perform? If personal skills and talent is required for performance and if party dies, so in that case, can legal representative perform? No. So in that case, what will happen? Contract will be discharged. So who can perform? Close friend of X, agent of X, successor of X, none of the above. So answer is none of the above. Nobody can perform because personal skill and talent is required for performance. I hope this is clear to everybody. And friends, here we are done with 80 MCQs of Indian Contract Act. Yes, with the Yodha series with Professor Meet Sachdev from K SHAH Classes. Friends, I hope this was useful. If you think these videos are useful, please come tomorrow also. Tomorrow we are going to do the next chapter, that is elements of company law. There are many questions which they ask you. Yes, technical questions and everything will be discussed in the same manner as we did today. So see you all tomorrow in elements of company law. If you like this video, just hit the like button, put a small comment, and see you all tomorrow. All the best. Good luck for your exams. Keep